Hello, everyone. Welcome to Court with Krissy. Time for an update. She's back. And I'm sort of shocked it took this long. But, like she mentioned during her last sentencing, she will always resist arrest. And that she did. We've got new charges. To keep track of all the BRINK appearances, I've created a playlist. It's called BRINK in the Clink. So, subscribe. I hope you like it. Court with Krissy is now in session.
Are you Chelsea Brink? I have to hear from you, ma'am.
Yeah.
All right, thank you. I'm Judge Hesselink. I'm coming to you from the district court. You're here today because of an arraignment. There's actually two files, a new file and a probation file. Let me call those cases. The first one is the State of Michigan versus Chelsea Brink, file 25-44174-FY-3. That is set for a new arraignment. And we're also here today on the State of Michigan versus Chelsea Brink, file 25-44051-F3. That's a probation violation file. Let me turn to the first new file. With me today to assist in that is Richard Trush, defense counsel, and Mr. Fortier from the prosecutor's office. The new charge against you reads as follows. It says that on or about November the 18th of 2025 in the city of Gaylord, Otsego County, in count one, you did commit the offense known as police officer assault, resisting, or obstructing. It says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Colton Huff, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. That is would normally be a felony offense with a 2-year and or $2,000 fine. However, you've also been charged as a habitual offender fourth offense notice, which has the effect of enhancing the sentence. That notice says that you were previously convicted of 3 or more felonies or attempt to commit felonies. In that on or about October the 13th of 2020, you were convicted of the offense of police officer assaulting, resisting, or obstructing in the 46th Circuit Court for Otsego County in the state of Michigan. On February the 5th of 2019, you were convicted of the offense of attempted arson, preparation to burn in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about February the 8th of 2018, you were convicted of the offense of felony kidnapping, custodial interference in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, there is an enhanced penalty, and because the underlying offense has a penalty of less than 5 years, the new penalty would be up to 15 years in prison. Do you understand the name of count one to be police officer assaulting, resisting, and obstructing?
Yeah.
Do you understand the maximum penalty under the habitual fourth offense notice for that charge is now up to 15 years in prison? I'm sorry, I have to hear something from you, either yes or no, ma'am. I'm sorry, I was not able to hear you. Thank you for making it a little bit louder. Count two reads as follows. It's entitled police officer assaulting, resisting, or obstructing. It says that on that same date and time, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Jacob Depew, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. Again, that would normally be a felony offense of 2 years and or $2,000 fine. However, you have also been charged with the habitual offender fourth offense notice that I just read to you on as to count one. That now applies to count two to make that a felony offense with a maximum possible penalty of 15 years in prison. Do you understand the name of count two?
Yeah.
Do you understand the maximum penalty for count two?
Yeah.
All right. Count three is the name of that offense is Mail and Mail Depository Protection Act, also involving mail theft. It says that on that same date, time, and place that you did take, hold, conceal, or destroy mail addressed to another person, that is Lisa's Tavern, with the intent to deprive that person to whom the mail was addressed of the mail, contrary to the Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 1 year and or a $500 fine. Do you understand the name of count three?
Yeah.
Do you understand the maximum penalty for count 3?
Yeah.
The final count, count 4, reads as follows. It says that on that same date, time, and place that you did commit the offense known as trespass, in that you did remain without lawful authority to remain on the lands or premises of Lisa's Tavern after being notified to depart therefrom by Elizabeth Arndt, who was the agent of the occupant of the lands or premises, contrary to Michigan compiled laws. That is a misdemeanor offense. It is a maximum penalty of 30 days and or a $250 fine. You understand the name of count 4?
What is it?
It's called trespass.
Oh, yeah.
You understand the maximum penalty of 30 days and or up to $250 fine?
Yeah.
All right. You have certain rights, and I want to make sure that you understand those rights so you can decide what to do with them in the future. Do you have any questions about any of those rights?
No.
Do you believe that you understand those rights?
Yes.
All right. Mr. Trush asked her right to an attorney. Have you had a chance to speak with her about that?
I did, Your Honor. She has been screened and qualifies for counsel. Again, traditionally, I think she's been represented by Mr. Brown. I expect he'll be appointed in this matter as well.
All right. Ms. Brink, until you have a chance to speak, with your attorney, I'm going to enter a not guilty plea on your behalf in order to protect your rights. Because you've been charged with felony offenses, I'm also going to set some quick court dates to also protect your rights. The first date is called a probable cause conference. That'll happen in the next 7 days. That's a chance for your lawyer and the prosecutor to speak to see if they can resolve the case quickly. In addition to that, within the next 21 days, we'll set a preliminary examination date. Now, that's a short hearing in district court in front of me as the judge to determine whether or not the prosecutor can show a small amount of evidence called probable cause that you've committed the crimes that you've been charged with. That is not a determination of guilt or innocence. It is simply a check to make sure that there's sufficient evidence to proceed with the case. Do you have any questions about those 2 court hearings?
No.
All right. What we're going to do next is address the issue of bond. So I'm going to listen to both of the attorneys, and then I'm also going to give you an opportunity to tell me what it is that you want me to know before we make that decision. Mr. Fortier, as to bond.
Your Honor, I did submit a bond recommendation form. In it, I want to note that she is on probation currently in case 2544051-FY, where she was sentenced to 6 months probation on a retail fraud 2nd degree and 2 counts of attempted resisting and obstructing a police officer. She was sentenced on October 17th, 2025, so just about a little over a month ago. I think based on the fact that she was out on probation for an assaultive offense, she's got assaultive offenses in her criminal history. She does present as a risk to the community at large. The court's obviously well aware of issues that Ms. Brink has. She's continuously picking up trespassing and R&O charges when the police are called. So based on that, I think a bond amount of $10,000 cash or surety would be adequate. I would also ask that, in addition to the standard conditions of bond, that the court order no drugs or alcohol be consumed, along with no marijuana, and that she participate in a substance abuse testing or monitoring program at the discretion of community corrections. Ask that she would report via community corrections, and that she participate in a specified treatment program, specifically with community mental health. I know she had indicated prior circumstances that she was involved with them. However, I'm not sure the extent of that involvement right now. I think it needs to continue, or at least be essentially restarted if it's not happening. I would also ask that she have no contact with Lisa's Tavern, that she not re-enter Lisa's Tavern, and that because she is charged with an assaultive crime, on top of the fact that she's got a felony criminal history, that she not possess any weapons or firearms. And that's it.
All right. Mr. Trush, your thoughts?
Thank you, Your Honor. In regards to bond on this matter, a few things that I think are important Given the circumstances, we expect some amount of cash bond is going to be put in place here. I would indicate Miss Brink has substantial connections to the community. She's essentially lived her entire life in Otsego County. Um, I think the court is familiar with some of her economic circumstances. She reports that she's homeless. I know that she has reported that to the court consistently, I think, in other hearings, which I wasn't a party to, but happened to be present and observe. She reports that she struggled to get a job since being released from prison, with a felony on her record. She reports that it's disqualified her from a lot of jobs. She reports that she's always appeared. And again, I would just indicate to the court, I think that some cash bond is surely going to be put in place here. $10,000 seems high. I would suggest to the court a $5,000 bond is more appropriate. And I would suggest to the court, again, the court I think is aware of some of her other economic issues. And frankly, the fact that she has some other matters, which frankly, if she had available funds, I think would be more appropriately put to those than to a bond here. Thank you.
Ms. Brink, you do have the right to address me as to anything that you think would be important for bond. I would simply caution you that not to make any statements about the underlying facts of the case because we are recording this and it could be used against you later. But if there's anything that you want me to be aware of, I'd be happy to listen to that now.
I'll stand mute.
All right, thank you. All right, I do note, as the prosecutor indicated, that Ms. Brink has just recently been sentenced on a case that involved, at least in part, resisting and obstructing or attempted resisting and obstructing police officers on the same offenses that she's now alleged to have committed on this particular case. She was on probation at the time she was alleged to have committed these charges. That she has ties to the community, but she has indicated to me in not only that previous sentencing, but in the other cases that she's been involved with the court, that she is homeless. I believe that she sold her home that she had here in Otsego County a couple of years ago and used that money basically to stay in hotels for a little less than a year. She has not, to the best of my knowledge, had any long-time employment, if any employment at all, in the last year or so. So while she is well known to the court system, she has very limited things that tie her to this community other than the fact that she may have people that she knows in the area. So because of her inability to keep herself out of trouble and the fact that she is being violent towards our police officers, I believe that a cash bond of $10,000 cash as surety is appropriate in this case. Conditions of release on that bond include personally appearing for all court dates set by the court, abiding by any judgment of the court, not leaving the state of Michigan without prior permission of the court, not committing any crime while on release, and immediately notifying the court in writing of any change of address or telephone number. She must also not use alcohol, marijuana, or any illegal controlled substances while out on bond. She must participate in a substance abuse testing or monitoring program through community corrections. She must participate in a specified treatment program for any physical or mental condition, including substance abuse, and that was specifically would be community mental health, and follow all recommendations of that assessment. She may not, because of her danger to the others in the community, she may not purchase or possess a firearm or other dangerous weapon while out on bond. She may not have any contact with, direct or indirect, with Lisa's Tavern. That means she may not call it, she may not show up in person, she may not use the internet or social media. No contact means no contact. Finally, she may not enter Lisa's Tavern in Gaylord as well. And then upon her release, she must contact community corrections within 24 hours of her release so that they may monitor her while she's on bond. Ms. Brink, do you have any questions about those bond conditions?
No.
Mr. Trush, anything?
No, Your Honor, thank you.
Mr. Fortier, anything else?
No, Your Honor.
All right, Ms. Brink, we also have one additional matter. Before I forget, Deputy, could you make sure that Ms. Brink gets fingerprinted on this new charges as well?
Yes, Your Honor.
Thank you very much. All right, Ms. Brink, we also have a probation violation issue. The allegations made against you on that is that you were charged with a new criminal offense of larceny, resisting, obstructing, and aggravated assault on 11/18 of 2025. That's the charges that I just read to you. Well, I'm not sure if that's exactly the way it should be read, but you've also been charged with police officer resisting and obstructing, and trespassing, and mail theft. The recommendation is that you serve 93 days in jail and that you be discharged from probation with fines and costs preserved. Do you understand the nature of the allegation made against you?
Yeah.
Do you understand the recommendation as to what would happen if you were to admit or be found guilty of that?
Yeah.
All right. I'm going to assume that you wish to have an attorney represent you on that matter as well. Is that correct?
Yeah.
All right. And I will, because I've just heard that you have qualified for court-appointed counsel, I will appoint court-appointed counsel or send that to Mr. Gilo to determine who should be your lawyer in that. I'm going to enter a not guilty plea on your behalf until you have an opportunity to speak with your lawyer about that. And then we're going to set a court date in conjunction with your new felony offense so that they're both heard at the same time. I don't know what that date's going to be yet, but we'll have that done for you. And we'll send the notice to you at the jail or at the address that you give us as to where you want mail sent to. Where would you like to have notices and mail sent to, Ms. Brink?
I'm in jail. What do you mean?
If you get out, obviously, if you're in jail,
I'm not
we'll
gonna
send it
get
to you
out.
there.
I'm homeless. I have no job and I'm homeless. I'm not getting out.
All right. Does that mean that you don't want to have a mailing address to where you can pick it up from
Right.
somebody else?
Right. I got no mailing address.
All right. So we'll send the notice to you at the jail. Do you have any questions about that?
No.
All right. That's all for today then. Thank you very much. You're free to go.